Hey everybody, Tom Woods here. Let me get, let's see if I can get Mark back on here. Oh, there he is. Hello. All right. Before we do anything, let's make sure everybody can see and hear us. So if you can see and hear us, can you type a 1 in the chat? And then we'll know. Let's check quickly. By the way, that is coming through very loud. Oh, there we go. Good. Good. Okay. People can see and hear us. Well, welcome, everybody. I'm so glad to welcome Marc Victor. I don't remember how long ago maybe I met you at an Ernie Hancock event or something out on the West Coast at some point.
Probably.
Somewhere in Arizona, maybe. But anyway, I just know that you're with Attorneys for Freedom. And without giving any details, we'll just say that I had a situation with a desperate person, and I said, the only person I know who can help you is Marc Victor, and you did help that person. Maybe you have a more specific introduction for yourself than that, but that's the most important thing.
Hey, Tom, so I won't be able to see the people who are listening, only you, or how does it work?
Yeah, they won't, but in the chat window, you'll be able to see people typing, and then in the Q&A tab, we'll have the questions.
I see. Okay, well, whenever you want me to get started, I'll do a little bit of an introduction and just start chatting.
Yeah, no, I say absolutely go right ahead.
All right. Well, hi, everybody. My name's Marc Victor, as Tom said. And by the way, I'm very honored to be asked to even be presenting here and be associated with Tom, who I've admired over many years, another fellow solid libertarian. And, you know, we libertarians don't have to agree on every little thing. I think we agree on the non-aggression principle, as I do. I consider myself a libertarian for probably about the last 30 years now. And so anyways, I see libertarianism as a big tent, but I'm also a criminal defense lawyer for the last 30 or so years. And I've been representing people in mostly major felonies, from first-degree murder with the death penalty alleged, which I have represented people at trial on many occasions, all the way down to crazy little misdemeanors. And also I represent people not just here in the state of Arizona, which is where I am right now, but across the nation. And indeed, I have cases in both state and federal courts across the nation. Also, I've done many appellate cases as well. I've argued in front of the Ninth Circuit and had other cases in federal districts as well as state courts. So today, I want to talk a little bit about owning a firearm. I think it's a really good time to talk about guns, by the way. I wasn't intending to say an awful lot about Second Amendment jurisprudence, but heck, since I stumbled on this, I think that a Second Amendment law has never been in better hands than it is right now. It doesn't mean it's perfect, and we're still going to have cases that we don't all agree on. But the court is more pro Second Amendment right now than it has ever been. It wasn't until Heller came out in 2008. We were still debating at that time whether, of course, I was not debating. I thought the question was settled about whether or not the Second Amendment actually protects an individual's right to keep and bear arms. Well, it wasn't until 2008 in the Heller case that the Supreme Court finally said, yes, that's the correct interpretation. And then, of course, you all know we got the Bruen case more recently, and they decided that, yes, your right to keep and bear arms isn't just confined to inside the home for self-defense, but you can also take your gun outside the home, subject to some restrictions, and that's what's being litigated right now. I think a lot of people in the gun community don't pay enough attention to what else happened in Bruen. They made a major change in how Second Amendment cases are interpreted, and we're in for quite a few interesting cases coming up in Second Amendment jurisprudence. If anyone wants to ask questions about that at the end, I guess the only other thing I'll say by way of introduction is my law firm, the Attorneys for Freedom. Yes, it is as it sounds. All of my lawyers are hardcore pro-freedom activists. They have to agree with what I call the live and let live philosophy, which is a global peace movement. You will recognize it. It's very similar to libertarianism with a substantial moral component that's completely voluntary. So while we say people are required, and I'll say for this crowd, to comply with the non-aggression principle, they're not required to be excellent humans, as we like to say in the live and let live community, but we certainly encourage them to be so. So if you're interested in that, you can check out liveandletlive.org. I don't think if you're a real libertarian, you won't find anything there to disagree with, and you may find an interesting global peace movement that is underway that you didn't know about until now. Okay, so I want to talk about the 5 most important things that I think responsible gun owners ought to know. And incidentally, I've been speaking on these types of issues for at least 25 years now. I speak at some of the major gun shows in Arizona, and I get hit with a lot of questions from responsible gun owners about, generally hypotheticals. And so this talk is really about things you probably mostly wouldn't read in a textbook or hear from other people, maybe who are just sort of self-defense, either interested people or even lawyers who do self-defense. But instead, these are things that I want you to know as a responsible gun owner to stay out of trouble. If we run out of time, then that'll be all I talk about. If we got some more time, then maybe I'll get into a little bit about interacting with the police. We could even get into some Fourth Amendment law. But I see some questions popping up already. I don't know if I should read some of these. Oh, one of them mentions my Attorneys on Retainer program. Thank you for that. That's true. If you're a gun owner, you can check out our Attorneys on Retainer program if you're interested in that. So let me get into the very...
Let me jump right in just for one quick second.
Okay.
I'll keep an eye on the questions, which are actually in a different tab, the Q&A only tab. I'll keep an eye on those, and then I'll feed them to you after you're done.
Okay, sounds excellent. I appreciate that. So I'll ignore the questions for now.
Because otherwise, like if I'm on screen, I'm just sitting here like a dope, so I turn my camera off, but I'm still sitting here.
All right, brother, sounds good. I'll defer all of that until the end. So let me start with the number one most important thing that I think you should know if you are a responsible firearms owner. And let me say it as delicately as I can. Just shut up. Really, just shut up. Now, the younger Marc Victor, who was a brand new lawyer, might have just stopped there and just left it, don't talk to the cops, and moved on. But the more experienced criminal defense attorney, Marc Victor, knows that you're not going to listen to my advice unless I give you some more reasons to listen to my advice. But let me point out something first. If you ever hear the police reminding you about my advice, that should strike a chord in your head. Now, why would they remind you? Okay, it's called the Miranda rule. People are familiar with it. Sometimes they don't realize that the police only have to read you the Miranda rule if 2 things are happening at the same time. Number 1, you are under arrest. And number 2, you are being interrogated about the reason you're under arrest. So what that means is sometimes police officers can play games, right? Maybe you're not technically under arrest yet. They can ask you all the questions they want without reading Miranda. So be aware of that issue. Second, even if you are under arrest, they don't have to read you Miranda unless they are interrogating you. And both of these things require a little bit more definition, but asking you routine background questions, what's your name, where do you live, what's your date of birth, that is not an interrogation. So they can ask you those questions. But if they're reading you those Miranda warnings, the right to remain silent, anything you say will be used against you. I want to pause on that one for a second. Let's break that down and think about it. Anything you say will be used. How will it be used? Against you. Think about that. And also, some of us, maybe a tad jaded criminal defense lawyers would say, what they should say is anything you say And some things you didn't even say will be used against you. Yeah, this happens sometimes. Keep in mind, unless there's a body camera, you're relying on that police officer to write down what you're saying. And then, of course, they tell you you have a right to an attorney. And if you can't afford an attorney, one will be provided for you. Those four things together, those are the Miranda warnings. If you're hearing that, you should remember my advice to just shut up. I know there are some other people, few criminal defense lawyers disagree with that, but there are some out there. But there are other people who say, no, 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 say this, say that, say I was in fear for my life. I reject that. So some people will still talk. It seems pretty simple that I would say just shut up and move on. But some people think, well, if I don't say something, the officer will conclude that I must be guilty of something, right? If I'm innocent, why aren't I saying something? Or maybe if I don't say something, he'll arrest me or something along those lines. Well, you should know your silence is not used against you. Now, this is true across the nation. This is true in state courts and in federal courts. This is a matter of federal constitutional law. So imagine, let's fast forward to your trial, right? You're worried that what's going to happen at your trial is the police say what happened. You say, hey, I want a lawyer. I'm not saying anything, something along those lines. And then the prosecutor is going to ask the police officer at trial, what happened? And the officer is going to say, well, I asked him to tell me what happened. And he said, I want my lawyer. And then the prosecutor is going to argue to the jury in closing argument, you must have been guilty because you didn't have anything to say or something along those lines, or use it against you. Okay, that's not the way it works. There are rules about how trials proceed. And the court got this one right, the Supreme Court. What they said is you have a constitutional right to remain silent. And even an inference that you remain silent, maybe because you were guilty, that can't be used against you. Therefore, the jury doesn't get to hear that you said, hey, I got nothing to say. Hey, I want my lawyer, something along those lines. The way that goes is the officer will testify and say, I got a call. I came to the scene. I saw so-and-so. I saw the evidence. I placed him under arrest and put him in the police car and took him to jail. They will skip right over the question, hey, do you have something to say? And your answer, no, I'm going to invoke my right to remain silent, or even better, I want my lawyer. Also, let me pause on that for a second. There's a difference between saying, I invoke my right to remain silent and saying, I want my lawyer. They're different. Here's how they're different. If you simply say, I invoke my right to remain silent, well, that's fine. Nobody can make you talk, but the officer can continue to ask you questions. They could come back in 5 minutes and say, hey, you sure you don't want to talk? We'd love to clear this thing up, right? I think that you're probably the good guy here, and I just need to get your statement to close my file or something. Remember, police officers get to lie to you, and they'll even say that on the stand. They'll say, yes, I lied. And upon being asked, why did you lie? They'll say, well, I lied to get the person to tell me the truth. So they can do that, no problem. And so if you, on the other hand, say, I want my lawyer, then questioning has to stop. They can't ask you again, have you changed your mind? Or is there something else to say? Or kind of work you to get you to say something. That would be a violation, and any statements you made would be suppressed. Okay, one other little point on that before I move off that one point. If you say, I think I want my lawyer, or something like, do you think I should have a lawyer? That's ineffective. That's as if you said nothing. You got to make a definite statement. I want my lawyer before answering any questions. If you say that, then they're done questioning you. And by the way, most police officers will honor that. So they won't use it against you, and it's not a reason to arrest you. They arrest you if they have probable cause to believe a crime was committed and you committed the crime. They still don't have to arrest you, but they can arrest you if that's the case. But in that calculation of what is probable cause, something that does not go in that calculation is your refusal to give a statement. So again, there really is no downside to keeping your mouth shut. And there can be big downsides for opening your mouth. For starters, some people, I think, incorrectly and irresponsibly advise that you should make this sort of general statement after a shooting, which is, hey, I was in fear for my life, and that's why I fired, and then just shut up. Okay, well, that could be great if that's the actual legal theory that we're using, but it may not be. What if the person was, say, shot in the back? You might not have a very good theory that I shot because I was in fear for my life, but it could be a good theory that you shot the person to protect a third party who was at risk of imminent death or serious physical injury, or some other theories. Here in Arizona, we have different theories that apply to crime prevention, other reasons, I should say, to shoot and kill a human being where you would still be justified even if you were not under an imminent fear of death or serious physical injury. Why open your mouth and limit your legal theories? Let the lawyer decide what the legal theory is before you make any statement. Remember, you can always make a statement later. Even if the police officer says, this is your last chance to make a statement, it's not your last chance. Your last chance to make a statement is in your trial after the government or the state rests its case and you're called to the stand. You have an absolute right to testify in your criminal case. You can make your statement for the very first time there. Sometimes I like to make the statement there. Sometimes I like to surprise the prosecutor with what our theory is. Make that decision with your lawyer later on. Also, having spoken with many clients who have called me immediately after a shooting, okay, this is a terrible time to make a statement. You might not think you're going to be freaked out or suffering from PTSD, but you probably will. This is like the worst time ever to be making statements to the police that are going to be written down or recorded in detail about little things in the case that will be used against you maybe a year or even 2 years down the road. What if you say something wrong? What if you make a mistake? What if you left something important out? All of that will be picked at by the prosecutor down the road. So it's a terrible time. You're going to be under incredible stress. You don't know what happened. You don't know what's going to happen next. You're worried about, whether you've just screwed up your life or whether you're going to have legal problems or who you're going to get for a lawyer, how much it's going to be, all these other problems. Terrible time to be making a statement. Also, as I alluded to earlier, and this comes out of some cases I've had this issue on several occasions where I'm reading a police report and I'm reading the statement and it always goes like this. The police officer will write, and then the defendant, Mr. So-and-so, said the following, comma, quote. They put a verbatim statement of what they say you said. Now, many occasions my clients have said to me, I never said that. Okay, so this is less and less of a problem as we have body cameras, right? But if you don't have a body camera there and you got the officer writing down the statement, how do you know that that officer is going to write it down correctly? They just may make an honest mistake. Maybe they're just negligent. Maybe they misheard something that you said and wrote it down incorrectly. And I don't know about this, but I will tell you, every time I've had a situation where my clients have said, I never said that statement in the police report, it's always been the worst statement in the entire case. So take from that what you will. I will tell you this, though. In one of the cases where it was a shooting case, where my client said, I never said that statement that was reflected in the police report, actually had a recording of the interview. And wouldn't you believe, my client never made what was represented to be the worst statement in the entire case. Okay, that was great because I had a recorded statement. What if we didn't have the recorded statement? He would have served many years in prison that he ultimately escaped from because the statement was recorded. Many times they're not recorded, right? A lot of those federal agents don't record the statements. They just write them down. Do you really want to trust your freedom, what could be 10 or more years in prison, to the accuracy of a police officer writing down the statements that you are making at the scene? Okay, don't do that. And I think we should talk about this as well. To be fair, most police officers, in my estimation, are generally good people trying to do the right thing. Most of them aren't bad guys trying to lock people up who haven't committed crimes or something like that. Most of them are trying to do the right thing. Not all of them. Some of them are bad. I've had officers say to me flat out, hey, Mark, I don't think that people who aren't police officers should have guns. Okay, do you want that police officer writing down your statement? There are also lying police officers. We have police officers in prison. You don't get to choose who shows up at the scene. Do you really want to trust your freedom in hopes that you get an honest police officer? You might be getting one of the minority of police officers who's willing to lie because they think you're a bad guy or they don't like you for some reason and write down something incorrectly. Like, I don't want to trust my freedom to what could be a bad or lying or dishonest police officer. Okay, so hopefully I've made the case to keep your mouth shut, at least at the scene. I've also had many experiences, by the way, in gun cases where my client did not make a statement, and then later on, after I spoke to my client, reviewed the police reports, reviewed the video, we made a statement. I've had occasions where I've called press conferences and said, hey, my client's going to make a statement, and the press has come and we've given a statement to the world, if you will, and it's turned out just great. So I'm not against making statements. I'm just against making them right there at the scene before you've spoken to your attorney, while you're under high stress and you're speaking to somebody who may or may not, either intentionally or unintentionally, be taking down your statement correctly. Okay, don't do that. Some people say, Mark, are there any exceptions to this rule? All right, there's some exceptions. There are no rules that don't have exceptions to them, right? So first rule, 911. Some people say, hey, Mark, what happens if I'm in my home and somebody breaks in and I have a shooting, I shoot them, and now they're on the floor bleeding out? Should I call 911? Okay, tough question. The right answer, in my judgment, is if you can get somebody else to call 911, get somebody else to call 911. Somebody who's not making a statement for you. And what should they say? They shouldn't give all the details about the incident. They should expect that the 911 operator will be asking about the details, but they shouldn't do that. They got to have their mind straight in terms of what we're doing. We're calling 911. We're saying there has been a shooting. Please send medical help. This person needs medical attention. Here's the address. Goodbye. Click. And that's it. Now, if you don't have somebody who can make that 911 call, you're going to have to make it yourself. You can't just let somebody bleed out on the ground. This, of course, will reflect very poorly on you at your trial if it goes that far. So you got to call 911 yourself. There's been a shooting. Don't say I shot someone. There's been a shooting. Here is the address. Please send help. Goodbye. Click. You know, you're going to be hanging up on a 911 operator who's going to be saying, yes, but what happened? You also know, by the way, that the police are going to be coming, and they're not going to know who's the good guy, who's the bad guy, and their attitude is going to be, I'm going home. Okay, fair enough. What should you do here? Make sure you do not present as a threat to that police officer. Said another way, absolutely, positively do not have a firearm in your hand when the police show up. If you're in a position to make sure that firearm can be cleared of rounds, put somewhere safe, I would make sure my hands are up when the police arrive. It's very clear that I am not a threat to them, right? Because accidents happen. Police can get excited. They're going home. You don't want to have an accidental shooting. You got to survive the fight on the street or in your house, if you will. You got to survive the police officer arriving. Then you got to deal with the fight in court. Okay, that's what we do. But in any event, that's an exception to the just shut up rule. Okay, traffic stops. People say, hey, Mark, I may want to try to talk an officer out of giving me a ticket. Okay, I don't have any big beef with this one. You're speeding down the road, you get pulled over. If you want to talk to the police and try to talk yourself out of a speeding ticket, that's fine. You don't have that much on the line here. Unless, of course, you've got a dead body in your trunk, or you've got, a whole bunch of drugs in your trunk or something like that. If that's the case, revert back to the just shut up rule. Incidentally, if you want to try to beat your speeding ticket, I have a little bit of advice for you here. Just own it, assuming you were speeding, right? This has happened to me on many occasions. I say, yeah, officer, you got me. No problem. I was speeding. I've gotten a warning in the last 5 times just using that strategy. I think they're so surprised that people might tell them the truth on the side of the road that you may get a break. Hey, that's up to you. But I got no problem if you want to break the just shut up rule so you can try to sweet talk yourself out of a traffic ticket. Incidentally, this is a big revenue generator for the state, so don't expect to be successful every time here. Also, as I mentioned earlier, after consultation, sometimes it makes sense to make a statement after you speak with an attorney. There can be good reasons to make a statement. I've done that in the past. That's an exception to the just shut up rule. In many states, and there's a couple things that are different state by state here, most states will say if you're detained, you have to at least give your true name. Okay, that's fine, no big deal. Look, if you don't give your name and you're detained, they're going to likely arrest you, take you to the station, and fingerprint you. If you want to avoid that aggravation, I have no problem with giving your name. And then in some places, Arizona included, if the officer asks, do you have a concealed weapon in your vehicle or on your person, you are required to answer that question. I do not recommend that you just volunteer that information if you don't have to, unless the officer is searching you and they're about to find a firearm. I don't think it's a good idea to let an officer be surprised about finding a firearm on you. They're not going to be happy that you didn't mention. So if they're patting you down or getting ready to pat you down, you might want to, if you got it on, you put your arms out here and say, look, I just want to let you know, officer, and of course, be very respectful. No reason to be a jerk on the side of the road. I don't care how you feel about police officers. It's not going to be in your interest to act rude to a police officer or be a jerk or get into arguments about con law or tell them they're doing an unlawful or an unjust job or something. Let that be the argument for the lawyer later on, not on the side of the road. But if they're not going to find that firearm and they're not asking about it, keep your mouth shut. If they're going to find it, open your mouth. Okay, so that's the number one most important thing. Just shut up. I'll just finish by saying I can't tell you how many cases I have had over 3 decades where I would have been able to either get the person off the charge or get a better result if they had just shut up. And all criminal defense lawyers know this. Very often, the worst evidence in the case comes from the defendant's mouth, him or herself. Don't be that person. Okay, number 2, self-defense. It's really all about one word: reasonableness. Almost every self-defense statute has the word reasonable or reasonableness in it somehow, some way. It would be almost like, imagine after the trial has concluded, right? The state presents its evidence, or the government, if it's a federal case, presents its evidence, and the defense presents its evidence. Both sides get to argue. Evidence is then closed. Arguments are done. And it's almost like the judge would turn to the jury and say, now, ladies and gentlemen, You've heard everything. You've seen everything. All the evidence is in. The witnesses have spoken. The arguments. Here's what we need to know from you. Is what the defendant did, is it reasonable? Because if it is, the defendant goes home. It's a complete justification. If it's not, well, then bad things are going to happen to the defendant. It all turns on reasonableness. That's what it's about. Considering all the facts and all the circumstances and everything that happened, your size, the size of the other person, what you were able to see, what you knew, anything in the background that's going on, everything together, is it reasonable? Now, you might say, well, Mark, how am I supposed to know what's reasonable in advance, especially if I got to make a split-second decision? Well, many legislatures, as a result of lots of cases, right? People are familiar with common law, case law. These rules have been worked out over hundreds and sometimes thousands of years. We got some rules that are basic rules. These are jury instructions. In fact, I really recommend, if you want to get a good idea of what the law is in your state on any particular issue, look up the jury instructions. Go to the, put your state's name and put revised criminal jury instructions. They'll come right up. Look at those. That'll tell you what the jury is going to hear. That's our best effort at explaining the law to lay people. We're going to make an important decision in the case. So we have some of these that I can tell you about. These are virtually, if not identical, very similar in every state. I can tell you this. If you're using self-defense, if you're claiming, saying, I acted in self-defense, if the threat against which you were acting was not imminent, it ain't reasonable. Okay, so what does that mean? Whatever the threat was, it's got to be right now. So if I say to you, hey, look, imagine we're not on Zoom and we're in person. I'm going to punch you in the face, but I'm going to go to the restroom first. I'll be back in 5 minutes. Okay, you can't punch me yet. You got to wait till I get back from the restroom for 5 minutes. That's what the law says. It's got to be right now. And that word imminent is in many, many self-defense statutes. So it's got to be happening right now. And so think about that, right? If it's something you're worried is going to happen, even down the road, more than a few seconds away, it may not be imminent, and a jury might find it was unreasonable. There's a video that's going around on the internet right now, getting ready to do a commentary on it soon, where a couple of guys, you may have seen it, they rang a doorbell, and it was one of these video cameras were there, and the person comes on and says, I'm not home. Turns out there were people home, and two guys on the outside decide to start trying to crash the door down there, kicking it and pushing it and trying to get the door down. But the door is still locked. And the person inside decides to grab his firearm and fires a bunch of rounds through the door. All right. We have a lot of sympathy for this situation, right? Somebody's smashing your door. They're trying to get it pushed down so they can do a home invasion. This may not be a good shoot. Now, we don't know all the facts, right? It's possible that if they had access to the camera and they could see that the guys on the outside had a firearm, they might say that's an imminent situation because if the door opens, they can fire the gun immediately. But without that knowledge, I start worrying about maybe you got to wait until that door opens so you don't get tagged with acting in self-defense in a situation that wasn't quite imminent. Okay, so you got to be very careful about that. And of course, the difference between reasonable and unreasonable is the difference between going home and maybe serving 10, 20, or more years in prison. So you want to get this right. Okay, another rule that I can tell you about reasonableness. If you're saying, I acted in self-defense, but it was only against words, mere words. Somebody said something horribly offensive, but it was just words. Sorry, you don't get to use self-defense against mere words. Now, there's sort of a gray line in here, right? You can imagine the most offensive thing possible that somebody could say. If that's all they're doing is saying that, then you don't get to use self-defense. But again, this is why you want to use a lawyer in these cases and keep your mouth shut, right? Because if you say at the scene, I punched him because he said this horrible thing, all right, you're in the wrong. But say you kept your mouth shut, and it turns out, as the person was saying the horrible thing, they were approaching you, fists clenched like this, they were bigger, those kind, you start rolling in other facts. Well, now you're acting not just in response to mere words, but it's words coupled with action. And once you bring the action in, okay, you're okay. So keep that in mind, no matter how offensive. I don't care if they say something about, your church, your spouse, your favorite sports team. They said something bad about Tom Woods. All these things that would infuriate you, none of them can support self-defense without more. Okay, keep in mind free speech, right? We support the right to free speech, no matter how offensive. In fact, if you're going to be for free speech, it's only in the area of offensive speech that you can actually make a stand and say, you know what? I support this person's right to say this horribly offensive thing. Keep that in mind if you're thinking about self-defense in response to words alone. And then final example I'll give you, I think in almost all jurisdictions, I know there's some weird rule in Texas, I haven't really studied it, but so I'll say almost all jurisdictions, you cannot use or threaten to use deadly physical force to protect property. Now, okay, you can argue about whether you like this rule or not. I think you could make a case that it's not the right rule. Maybe property over a certain value, you might have worked your life to accumulate this. It could represent a life's, work or something, or your retirement. If somebody steals that, that's a pretty significant injury to you. Maybe you should get to use deadly physical force. You can't. Now, again, like the mere words, right? If somebody's in your house stealing your TV set and that's why you shot them, you're going to be in the wrong. If, on the other hand, they're stealing your TV set and they're approaching you to maybe hit you over the head with it or something, now you're in the ball game where you can say, hey, I was really in fear of an imminent serious physical injury or death. You're going to have to get into that category if you're threatening deadly physical force, certainly if you're using deadly physical force, with very, very few exceptions. And there are some kicking around out there. Different states have different rules. Arizona has some areas where you can threaten deadly physical force, but you can't use it. But as a general rule, don't threaten deadly physical force to protect property. That includes a stolen car, by the way. Just don't do it. And then also keep in mind on this reasonableness idea, it's not who a bunch of your fellow libertarian pals or fellow gun owner pals, it's not what they think is reasonable. It's what a randomly selected group of people from the local community thinks is reasonable. All right, a lot of those people are going to think it's unreasonable that you had a firearm in the first place. So you don't really want to be in this position. You have no idea who's going to be on your jury, and this varies by community. It's one of the reasons that I'm very conservative in terms of my advice about when you can pull it out. Wow, we're already half an hour in, so I'm going to move on a little bit because I got 5 things and I've only covered 2. So number 3, here's something that I think a lot of gun owners don't really understand about what happens kind of in the back when us criminal defense lawyers and prosecutors, when we're dealing with a case, and I want to just tell you about it. And I'll give you an example maybe of how this comes up. And it comes up like this all the time. Client comes into my office, maybe charged with some kind of an aggravated assault or something more serious, and says, I acted in self-defense. Here's what happened. This happened, and this happened, and this happened. I said, wow, sounds like a pretty good self-defense case. I can defend this case. Happy to accept the case, and I take the case. And then I call the prosecutor, and I say, hey, man, I'm representing so-and-so, and I think my guy's got a pretty good self-defense argument. Here's why, and I lay out all the facts. Inevitably, the prosecutor is going to say back to me, Mark, those aren't the facts I'm working with. I got a completely different set of facts. So I can tell you, we criminal defense lawyers almost never argue about the law with the prosecutor. We know what the law is. There are a few cases on the edges where we may not be 100% clear about how the law applies. It comes up sometimes. But for the most part, we are arguing about the facts. Why is this important? Well, if there's 5 of them and 1 of you, you know you're probably going to get, at best, 5 different versions of the event on the other side. They may all get their stories together and they're going to say a version that doesn't help you. It's not just about what happened. It's about what the evidence that's going to be presented at your trial is going to suggest happened. So keep that in mind. Very, very important to remember what the witnesses say, how many. And remember, at your trial, if you get on the stand and testify, guess who the jury is going to think is the most biased person in the entire courtroom? That's right. It's going to be you. They're going to discount what you're saying. They're going to say, that's the defendant. He's the one going to prison or not going to prison. And so I'm going to discount everything they're saying. They're likely to believe the police officer. But if there are 2 or 3 or 4 people on the other side, even if they're telling a false story, it can be very difficult to show what the true facts are. Now, keep in mind that it's the state or the government that needs to prove the case beyond a reasonable doubt. But the truth is, jurors don't do such a great job, in my opinion. These are the same people that, vote for politicians that we don't like as libertarians, right? They had a chance to vote for Ron Paul twice, and they blew it. These same people are going to be on your jury. And they don't think so well, some of them, and they don't understand beyond a reasonable doubt and burdens of proof and presumptions and things like that, nor do they carefully go through the statutes, nor do they understand fine distinctions about mens rea, what's going on in your head. Did the person act intentionally, recklessly, with gross negligence? These are all very important distinctions that sometimes can be difficult for people who don't deal with this on a regular basis. I certainly would not want to trust my freedom to a bunch of randomly selected butcher, baker, candlestick maker types who don't do this stuff for a living. We're sitting on the jury with all kinds of biases and ideas about the world, deciding in a very quick, few minutes about things that law students spend months going through in law school. So, all right. So number 3, keep in mind when you pull that firearm out, it's not going to be just a matter of what happened. It's going to be a matter of who's saying what happened and what the facts are and what the fights might be over the facts of what happened, not just what happened and how the law applies. All right. Number 4, you've really got to understand this to understand gun cases properly. Mandatory minimum sentences. Okay, most people probably listening to this know what a mandatory minimum is, but just to be safe, mandatory minimum sentence is when the legislature tells the judge, hey judge, and they do this through a statute, of course, hey judge, if a person gets convicted of this crime, the least you can give them is X amount of years in prison. These are often 5, 10, 15, 20-year type sentences. You can imagine in gun cases, just like in drug cases, we see a lot of mandatory minimum sentences. Why is this a big deal? Well, almost all gun crimes are mandatory minimum sentences. It's a big deal because any criminal defense lawyer who's been practicing any length of time will tell you that mandatory minimum sentences rob people of their ability to take the case to trial. Now, why do I say this? Well, remember, the jury doesn't get to hear about the mandatory minimum sentence. They have no idea what the punishment is. So they might think, this person gets convicted, they're probably going to get probation and be on their way. I do think they think that about lots of drug cases. I don't know exactly what their attitude is on gun cases, because I think most people recognize that gun cases are generally pretty serious, but they're not going to know exactly what the punishment is, but you will. And when you're looking, just take a situation And we'll take our home situation, home invasion, 2 o'clock. And the questions you guys like to ask, it's 2 o'clock in the morning and I'm sleeping and I hear a noise and someone broke into my house and I got my firearm and I say, hey, get out of my house. And, there's a little bit of commotion. Maybe they turn and just as they turn, you shoot and you kind of get them in the shoulder. And it's a questionable shoot. Was the person retreating? In which case you can't shoot them, or were they still presenting the imminent threat of death or serious physical injury? Close call. All right, well, that's a case that you might want to take to trial. And you would want to take to trial if the judge was free to give you any particular sentence the judge thought was appropriate. If you're somebody, say you're an older person with no priors on their record and you thought you were acting appropriate and just made a split-second mistake, that's probably an easy one, even if you're found guilty, to get probation. But with a mandatory minimum of, say, 10 or 20 years, you're going to have a lot harder time rolling the dice going to trial. And the prosecutor knows this, right? Prosecutors say to me frequently, Mark, here's a plea offer. I know your guy doesn't want to plead guilty, but here's a plea. Come in, plead guilty. Maybe gets probation, maybe serves 6 months or a year even in jail or prison, but he doesn't roll the dice on a 10 or 20-year sentence. Now, if you're in a firearms shooting case and you get charged, you're going to find yourself very likely in this position. I have these discussions with people all the time, and they'll say, well, Mark, what are my chances of winning at trial? All right, officially, I'm never going to give you better than 50% chance. No lawyer who's practiced any length of time can actually give you better than 50-50 at trial because you just never know who's on the jury. But what if I pulled you aside and I said, hey, look, I really feel good about this case. 90% chance we're going to win at trial. Now, I could never actually say that, right? But imagine for the sake of this thought experiment that 90% is actually very accurate in terms of whether you would win at trial. But that's still a 10% chance you're going to go to prison for a very long time. I say to you, just from doing this so many years, even if you are looking at a 90% chance of winning at trial, if that prosecutor offers you a deal to go plead guilty and take probation, 99 out of 100 of you are going to take that deal. Now, I've been fortunate to have some clients who have, in that position, said, you know what, Mark, I feel like I got a good lawyer. I'm still going to charge ahead. I'm going to trial. And it's turned out great. We've had that happen. It does. But most people are not going to roll the dice. And the prosecutor knows that. That's why, in my opinion, we have such a high percentage of plea bargains in the criminal justice system. I say 95% of all cases end in plea bargains. That's actually a very conservative estimate. I saw a study came out fairly recently, at least in the federal system, that said 98% of all felony criminal charges in the federal system resolved by plea. Of the 2% that go to trial, more than 50% of those end in a guilty. That's a 99% chance if you're charged in the federal system, you're coming out with some kind of conviction. All right, so mandatory minimum sentences. If anything, I hope I've convinced you to be very, very conservative here in terms of pulling out your firearm. Because if you're charged, you're going to be very likely facing a mandatory minimum sentence, and you don't want to be in that position, even if you were in a good shoot, right? I mean, look, if it's a clearly good shoot, you're probably not going to be charged. I've seen very few cases in 30 years of doing full-time, hardcore, major felony, lots of gun-heavy litigation in criminal cases, and I almost never get a case that's clearly a good shoot where they're still charged. I've had several cases even very recently. We had 2 of them here recently within the last year where somebody shot and killed another person. And in both cases, they were good shoots and the charges were declined. So I think that happens more than you might think. The flip side of that is if you're charged, it's at least a questionable shoot. Remember, the prosecutor went to law school too. They're not idiots. They have expert witnesses as well who they bring in. Many of them on the more serious cases have review boards that they go through. They usually don't bring a case if it's a self-defense, if it's a valid self-defense shoot. The best you're going to get is a questionable shoot. And in a questionable shoot, you probably are not going to want to roll the dice. If you do, that's fine. And you can always take your case to trial. I mean, at our firm, we love going to trial. We love fighting about it, but it's not always in the client's interest. Okay, so that's number 4, mandatory minimum sentences. You're probably not going to trial. You're probably going to take a deal. By the way, when you do, you very likely will lose your right to keep and bear arms. But stand by on that. There was just a case that was decided in the Third Circuit. It's the Range case, R-A-N-G-E. In fact, I just got a video on this. I think it's on our website or our YouTube channel where I detailed this case. And as a result of Bruin now, there's a really good argument that even if you're convicted of a felony offense, that the Second Amendment prohibits the law from making you a prohibited possessor. Said another way, you still don't lose your gun rights, even if you're convicted of a felony. Stand by on that one. There's more litigation coming. And again, that was, I think, a Third Circuit case. Hasn't hit the Supreme Court yet. So eventually the Supreme Court's going to have to speak on this. And there's a lot to talk about. If you're interested in that area, I refer you to my video on the Second Amendment that just came out. If you can't find it, just email me, mark@attorneysforfreedom.com, and I'll send it right out to you. All right, the 5th thing, maybe the most important, I don't know. Okay, so you're thinking, maybe you're a responsible gun owner, you're carrying a firearm, and something is happening out in the world, and the thought has popped into your head, is this the time that I should be pulling out my firearm, yes or no? Okay, well, the perfect situation maybe is you give a call to my law firm, and I'll take your call 24/7, 365. And if you say, hey, Mark, is now a good time for me to pull out my firearm? I'm going to say, tell me what's happening. It's going to take about an hour to go through everything, so I feel very comfortable. I understand the facts. And then I'll give you my opinion about whether or not you can pull out a firearm. Okay, everybody listening to this already knows, because I talked about the imminency requirement, that isn't going to work. You don't have that kind of time. In fact, if you do have that kind of time, you can't pull it out because it's not imminent. So what is it I want in your head when you're thinking about this that you can do in just a few seconds? I think there's a way to reason through this. Let's just call this the Mark Victor test. Here's what I want you to imagine. I want you to imagine that if you pull out your firearm right now, like you're thinking about doing, you're definitely going to be arrested. You're definitely going to jail. You're definitely going to have a very high bond set. The judge may even set a cash-only bond, which I think should be unconstitutional, but they get set all the time to make it harder for you to get out of custody. I want you to imagine that you're going to be charged with a very serious felony. You're going to be facing one of those mandatory minimums. Let's just say you scared somebody with a firearm, you pointed it at somebody, and here in Arizona and in many other states, that would be a version of aggravated assault. In Arizona, mandatory minimum 5, maximum 15. You are definitely looking at that. I want you to imagine that you're going to have to hire a criminal defense lawyer who's going to be much more expensive than you wanted to spend money on, which was exactly zero. But if you want somebody good, they're going to be expensive. I can tell you the rates that I bill at are $6.50 an hour. I have many cases in my office at that rate right now. Do you really want to pay $6.50 an hour to defend yourself? Or at least you're going to wind up paying $4.50 an hour. Some of my other lawyers who are experienced are at $4.50 an hour. Imagine you're going to go through a long, miserable, stressful experience while this case proceeds through the system. You should imagine it's at least a year, and it's going to cause lots of stress. You're going to open your eyes in the morning, and this is going to be the first thing on your mind. And when you go to bed at night, this is the last thing you're thinking of. It's going to be a miserable experience. And then at the end of that, you probably still take a plea and lose your right to keep and bear arms. Okay, so take that whole package of stuff and let's call that being prosecuted, okay? So back to the moment where you're thinking about pulling out your firearm. I want you to think, if I pull out my firearm, I'm going to be prosecuted. What I want you to think about is, if I don't pull out my firearm, is what's going to happen worse than being prosecuted? Because if it is worse than being prosecuted, then I say, pull out your firearm. If being prosecuted is as I've just explained it, and again, you may not be charged, right? But I want you to imagine you will be. If being prosecuted is worse than what is about to happen if you don't pull out your firearm, then don't pull out the firearm. Okay, let me give you some examples how we can apply the Marc Victor test, and then I'll conclude at an hour here and open it up for some questions. An example of a time that I think is going to be worse than being prosecuted. If you don't pull out your firearm right now, you're going to be dead. Okay, putting aside questions of what happens after you're dead, let's just imagine being dead is worse than being prosecuted. Therefore, don't pull out, and then therefore do pull out your firearm. Being dead is going to be worse. Pull it out. Okay, example number 2. If you don't pull out your firearm right now, somebody else, maybe who you love or like a lot, is going to be dead or maybe seriously injured. Okay, I think I'd rather be prosecuted than have somebody I love or like a lot be dead or through a serious physical injury. Pull it out. All right, example number 3, actual example from one of my cases. I had a client who came in my office one time. He was charged with pulling out his firearm and pointing it at somebody. I asked him, why did you pull out your firearm? His answer back, well, Mark, I was disrespected by the other person. All right, nobody likes to be disrespected. Would I rather be disrespected or prosecuted? Okay, disrespect me all day long rather than prosecute me. There's an example of do not pull out your firearm. I hope you get the flavor of what I'm saying here. It's got to really be serious for you to pull out that firearm. Not serious enough that you've been insulted by somebody, not serious enough that you've been pushed by somebody or somebody said something horrible. And again, the smartest thing to do, we can talk about the Castle Doctrine as well. The smartest thing to do, and really everybody who talks about this agrees with this point, avoid the situation in the first place. Be smart. Don't go to places where you might have to pull it out, where it's more likely to pull out if you can avoid it. If you see a problem brewing somewhere, if you can exit stage right or stage left, even if the law doesn't require you to, say you're in a state like Arizona or Florida or Texas, or most states that are not on the East Coast or the West Coast that say you don't have to retreat. You can sort of stand your ground. The Castle Doctrine, if you want, and the Castle Doctrine is slightly different than that. We can talk about it if there are questions. But just because you don't have to retreat doesn't mean that that's not the smart thing to do. Live to fight another day, or live to see another day, if you will. Don't get into a gunfight or even a fist fight if you can be smart enough to avoid it. Because remember, sometimes the bad guys win those. It's not always, doesn't always have a happy ending. All right, so there's the 5 things that I think you should keep in mind if you're carrying a firearm. Just to recap very quickly: number 1, just shut up, don't make any statements. Number 2, self-defense is about reasonableness, and the people on the jury are going to decide that. Number 3, keep in mind, we being criminal defense lawyers are not arguing about the law. We're arguing about the facts. Think about how that may factor in to your willingness to take out a firearm. Number 4, mandatory minimum sentences probably will operate to convince you not to go to trial, which I think is a travesty of justice. Therefore, I advocate abolishing mandatory minimum sentences. Hopefully you do too. And number 5, what I want you to think about in terms of pulling out your firearm, imagine you're going to be prosecuted and it's going to be nasty. And if what's going to happen otherwise, if it's worse than being prosecuted, fine, pull out your firearm. If being prosecuted is worse than what's going to happen, keep the firearm holstered and get out of there, seek another resolution to the situation. All right, I'm going to stop there almost exactly at 1 hour, and I'll let Tom fire some questions off to me.
Okay, excellent. Thank you so much, Mark. Let's go now. You know what? Let me take a look at the question tab here. Okay, we got quite a few of them. I'm going to jump in and out of order. Can you start with "I want my lawyer" before they even read your Miranda rights?
Yeah, you certainly can. No problem. If you say, "I want my lawyer," but I think I would still wait till they say it. I don't want any chance that any one prosecutor is going to make an argument that you started with that before they read you your Miranda warnings. I think it's perfectly fine to wait. Look, you control whether you make a statement or not, right? They can't force you to make a statement. Let them read you the Miranda warnings, then say, "I want my lawyer." And again, in a very nice, polite way. It's not going to get you anything by being a jerk to the police officer.
Okay. What happens if you shut up, but your wife says something like, "We were in fear of our lives"?
Then you're going to be stuck with the wife's statement if that comes into trial. And it might come into trial and it might not come into trial. It'll depend on many different factors. This is a good example of a good time to talk to your wife, but how she should conduct herself as well. Other witnesses can say things as well. There could be 10 people standing around. They could all give statements. But remember, there are different hearsay rules. Like, for example, say the wife says something, there might be a hearsay objection. There's never a hearsay objection if the defendant says something that is being used against the defendant at the defendant's own trial. It's an exception, actually an exclusion from the hearsay rule. It comes in. So anything you say really can be used against you. If your wife or a witness says something else, a little bit different analysis applies.
When the police show up to reports of a shooting and they don't have any idea who is who, what's the best way to identify yourself as the good guy, to avoid getting shot or whatever?
I wouldn't well, to avoid getting shot, I would always, no matter who you are and how you're involved, keep the hands up, keep the gun out of your hands. You definitely don't want to present as a threat. But if the police don't even know what happened or who shot or anything like that, zip it. Sometimes you might even be in a good shoot, but there could be witnesses there who are friends of the person who was shot who are going to make up a story about what happened. Better to just keep your mouth shut. And again, it's very, very difficult to give really good advice that applies to every conceivable scenario. Like, I'll concede there could be a hypothetical situation where it makes sense to make a statement, but it would be very hard because, some people are able to speak more eloquently and under pressure and others can't. That's why it's a better rule as a general piece of advice to don't make any statements.
Okay. In a shooting scenario, if assaulted in any way, I heard you should request 2 ambulances. That way, you go to the hospital instead of the possibility of immediate arrest at the scene. Is that good advice?
It's a little bit of a slick trick, and there is some truth to this. If they're going to arrest you, right, and you have some injury, and of course they're going to check you out to make sure it's a real injury. So there are factors that come into play. But if you say, "Look, I have a real injury," and they may very well take you to the hospital and not arrest you. But I also think people get a little too focused on whether they're going to be arrested or not. Again, I know that's a big deal. Nobody wants to be arrested. But I'm more focused on the big picture about whether or not you're going to be prosecuted and tried and whether the case against you is going to be stronger or weaker. I keep my eye focused on that. Like, if I could be arrested and still have a stronger case at trial, I'd prefer that than talking myself out of an arrest, but maybe hurting my chances at trial later on.
Okay, let's see. Can you hunt on your own land if it is in a city or near one, especially if the sound could draw the police?
This is something that there are local rules about this. In many places, there are rules about discharging a firearm within city limits. So if you're in city limits, probably not. Also keep in mind, it will depend on the weapon that you're using. You're using a 50 caliber with a 1 mile range. You have to consider that different than a 22 handgun. If you're outside the city limits, well, then you may be on state land or on federal land, and there are different rules about that. You should definitely check the rules of the land that you're on before you either take or discharge a firearm.
Okay. Does what's reasonable change from state to state? Even if not codified in law, should we hold ourselves to a higher standard based on how our state has ruled in previous cases?
I think it's fair to say that there are different standards of reasonableness throughout different communities, right? What's reasonable in the open sky area of Montana in terms of carrying a firearm and doing certain things with a firearm is probably not going to be seen as reasonable in the middle of New York City. But that said, I had a client who it was a very high profile case who took his AR-15 for a walk to Sky Harbor Airport to make a point about the Second Amendment. And it's true, in Arizona, you can put your AR-15 over your shoulder and walk right down the street, permit or no permit. But sure gathered a lot of attention. He did get arrested, but I got him off of that charge and I got his AR-15 returned. But what you can do legally and what is smart to do are often two different things.
All right, let's see. How about, so if given a deal by the DA, you've still got a felony and can never own a firearm again, right? So you can only defend your life one time?
Well, it definitely depends on lots of different factors. First of all, different states have different rules about felony convictions. In some states, like California, and again, I'm not licensed in California, but my understanding is that if you get a felony in California, you can't fix it. It's a permanent disability. If you get a felony here in Arizona, depending on the type of felony, you can fix it. And so different states have different rules. But, again, you're making a decision between going to prison right now or having a huge risk and trying to stay out versus maybe losing your right to keep and bear arms. The more critical question, in my view, is staying out of prison right now. And I do have people who struggle with this and say, look, Mark, I'd rather be out of prison and lose my right to keep and bear arms than in prison, because I took a big chance and you still got to lose your right to keep and bear arms if you get convicted. So I think that's the lower concern. When you're looking at a major felony, really and I tell people when I meet with them, what I care about is keeping your rear end out of prison. Before we talk about anything else, your right to keep and bear arms or terms of probation or any of that stuff, let's keep your rear end out of prison first.
Somebody asked, what about brandishing? In my state, it's a misdemeanor. I'm sure each state is different. What can you say about brandishing?
Yeah, I'm very surprised that brandishing is a misdemeanor in some states, but California, for example, they have a misdemeanor brandishing. We don't have that in Arizona. In Arizona, when you brandish it, it's a felony, a disorderly conduct, which is a dangerous offense here, and it's mandatory prison. Also, brandishing is a very loose kind of a definition. It's not clear exactly what brandishing is. You get into gray areas. Some people will consider it brandishing if you just put your hand on a firearm, maybe pull up a jacket to show it. Others say, no, you got to take it out even if you're not pointing it around. So it's a very squishy definition. And some states have gone away from brandishing and instead given a more detailed definition. But again, remember, it's all about reasonableness, and you can only use the least amount of force that is reasonably necessary under the circumstances. So if you could have gotten the person to leave you alone by going like this, leave me alone, that's all you get to do. If you could have said, hey, I got a gun, leave me alone, then that's all you get to do. You don't get to just pull it out and shoot somebody, right? Maybe I've had some cases where people have pulled it out and then shot a couple rounds in the air on the ground. It's a last-ditch attempt to say, look, leave me alone. That usually goes a long way with the prosecutor. In fact, I have one of those cases right now. And again, we're fighting about the facts, but our position is that he shot up in the air 3 times first to have an escalating use of force. And so I do like the idea of do the least amount you can possibly do to repel the attack.
Okay, so Carl has a couple questions. One of them has to do with, do you think, or what is your understanding of the UN's role in disarming the U.S. is the first thing, and second, Soros bought and paid for judges and other officials and other wealthy criminals, Gates, Bloomberg, who are working both overtly and covertly to end gun ownership. I don't want to editorialize about the questions, but to me the interesting thing about the Soros thing is that there really are district attorneys that seem to have been put in there in part by Soros money, and that they, you and I don't want to live in a police state, but at the same time, if I'm paying for the police, I want them at least to protect me and not make me into the victim. I don't want to go to prison because I defended myself. And it does seem that there are parts of the country where the normal order of things is being turned on its head, and I think maybe not by accident. So what do you think about all that?
Well, as to the UN, I have never had any interference with from the UN in any case I've ever done in 30 years. So I can't really speak to that. Regarding these prosecutors, I will tell you this. I agree that the George Soros situation, in fact, I have some friends who are prosecutors, 3 of them who are lifelong prosecutors in California. And I can tell you they're very upset because some of these district attorneys in California, it's not that they're being too harsh. It's that they're not prosecuting certain crimes, specifically shoplifting and things like that. And you're seeing now a market response to that. Some of these stores, we're finding out, maybe unsurprisingly, they don't like being burglarized or robbed even. And so they're shutting their doors and leaving these communities, and maybe that's some sweet justice. But I will say this, and I don't, at risk of, I'm worried that I wasn't going to say anything controversial tonight, so here it comes. I'm generally a pretty good defender of the criminal justice system. I can tell you from 30 years practicing criminal defense, not once have I had the opportunity to say my client has been treated differently because of the color of his skin or his nationality. This stuff about institutional racism, I have not seen it. I don't know anybody who's seen it. I think it's absolutely bunk. I'm not saying there aren't some people in the system who are racist. There are racist people everywhere. But to call the justice system institutionally racist, false. I will say the same thing with corruption. The vast majority of judges and prosecutors are not corrupt, especially in the federal system. For the most part, if you if you disagree with me, go to federal court and watch some of the court proceedings. Our beef, in my opinion, when I say our beef as libertarians, is with the law. The law is wrong. We have victimless crimes. We got to get that out of the system. And that creates a lot of problems. And we shouldn't understate that. I don't mean to give it short shrift. But corruption, okay, there are some cases, but our system the corruption is not the problem in the justice system.
Okay, let's see. Historically, jury nullification is used to clear the accused of prosecution under an unjust law. Could jury nullification convict an innocent person who was actually justified in what he did or just plain innocent?
No, jury nullification is about the jury nullifying the law, saying, look, we don't think the law is correct in this circumstance where we would otherwise convict, or said another way, notwithstanding the fact that the prosecutor has proven each element of the charge beyond a reasonable doubt. We don't like the law, so we're going to find the person not guilty. I'm a big fan of jury nullification. And, there are two contexts here for jury nullification. In the context of what we have now, where the law is wrong, frankly. We have victimless crimes in the law. I'm a big fan of jury nullification, where I should be able to argue to the jury, take a place, for example, where marijuana is still a crime and somebody's charged with simple possession of marijuana, a competent adult, let's say. I should be able to stand in front of that jury and say, ladies and gentlemen, even though they proved my client was in possession of marijuana, this is a stupid law, find him not guilty. The other context is, if you can imagine our sort of perfect or ideal libertarian society, for those very few cases where the right thing to do is to violate the non-aggression principle. And you could come up with hypotheticals that are fun to talk about here. That's the case where you want to say, ladies and gentlemen, even though the law works here, the facts were such that let's give this person a pass. They did the right thing, even though they were technically an aggressor. And so let's let them off. So I'm a big fan of jury nullification, just so you know. Lawyers are absolutely prevented from discussing this with juries right now, and jurors are required to take an oath to swear to follow the law as the judge has given it to them. I would do away with both of those things.
Okay. Several years ago, you spoke at a Doug Casey event. I believe you said at the time that we are living in a police state. Are we in more or less of a police state now?
That's a good question. You know, it all depends on, and by the way, thank you for remembering that speech. That was such a fun talk I gave at Doug Casey's event, and I gave many examples of why I thought we were in a police state. Look, I don't want to overstate or understate the case. And early in my career, I said we were in a Nazi police state. We're not in a Nazi police state. Do the police have way too much discretion and authority? Yes, they do. Are we in a worse police state now? In some ways, yes, and in some ways, no. Look, many of these laws, we've got marijuana has dramatically changed since that speech. Euthanasia is moving in the right direction. Gambling is moving in the right direction. Second Amendment rights are moving in the right direction. All that, it cuts against the idea that we're in a police state. But on the other hand, we have a conservative court. And conservative court generally allows the police too much discretion on the side of the road. It's the liberals, it's the Marshall and Brennan court, the liberals that wanted more privacy and less intrusive police state. So I'm very mixed on the court. They're great in the Second Amendment area. I expect someday we'll get a good case on the Commerce Clause. But I worry that when conservative morality is being sought to be put into the law, I worry that this court is not going to do such a great job keeping it out. So it's a mixed bag. In some ways, we're more of a police state. In some ways, we're less of a police state.
Okay. Do you recommend carrying less lethal options in addition to a firearm?
You know, I think it's personal choice. How much stuff do you want to be bogged down with? Sometimes I don't want to carry a firearm just because I don't want to carry a firearm. I can't imagine carrying a firearm and then carrying pepper spray and then carrying some other weapons. If I got to carry that much stuff, I probably shouldn't go to the area you're thinking of going. So it's really an individual preference. I will say this: if you are going to carry, you should do so responsibly, which means absolutely no alcohol, no marijuana, no substances that are impairing. And then there's a very controversial point. Lots of people will disagree with me here. Unless you are in a situation where you very high chance of a problem, I think carrying with a round in the chamber can create problems. Now, look, I recognize there's a tactical disadvantage. You got to go like this to load the round in the chamber. I get that. So I recommend being at that tactical disadvantage so you can reap the benefits of not having an accidental discharge. More people, if you want to know the number one reason competent, responsible gun owners come to my office for representation on felonies, it's the accidental discharge. You can avoid that by carrying with a round in the chamber.
Let's see.
I should say by not carrying with a round in the chamber.
Right. Okay. So I've got a couple questions that were submitted privately. I think that was done by mistake. I thought warning shots were always a bad idea because you had a chance to retreat and didn't.
You know, it depends on the circumstance. In the case that I'm using, the person couldn't retreat. They were boxed into a closed area and they shot up into the air rather than shoot the person in a last-ditch attempt that they would stop attacking. It didn't work out. My client actually did have to shoot another person. But it depends on the circumstance. Again, if you can retreat safely, you should, whether you're required to legally or not. Some states require that you do. These are the ones that are sort of anti-stand your ground states, and they're in the minority, by the way. They say if you can retreat in complete safety, then you must before using deadly physical force. I think that's a good rule generally. But also I'll point out, if you can retreat in complete safety, you're probably not dealing with an imminent threat. And so you probably don't have any other choice.
You recommend saying, I want to speak to my lawyer. That presumes we have a lawyer lined up. Should we get a lawyer like we would get an accountant or doctor? Do you recommend getting to know a lawyer just for ordinary life, or particularly in situations such as getting a firearm?
Well, two answers here. Number one, you don't need to actually have a lawyer to say, I want to speak to my lawyer first. So it doesn't change anything about the advice. But second, yes, I do think it makes sense to have somebody ready to go just in case. You hope you never need this person. Somebody alluded in the chats to our attorneys on retainer program. I think it's the best program in the nation. By the way, if you go there now, you won't see all of the new things we've added. On September 5th, we're going to be adding a whole new slew of things to the attorneys on retainer program. In essence, it kind of works like this: $100 to sign up, $35 a month. If you get into a self-defense shooting, even if it's a bad shoot, and my program is the only one who can say that because I'm a law firm, we'll defend you free of charge, including all costs, all the way through a jury trial. No problem. To me, it's a win-win. It's worth $35 a month. And you get to know your lawyers in advance. We're 24/7, 365. If you do get into a situation like this, it's good to have somebody right there ready to go. Your life could depend on.
So what's the website for that again?
People can go to attorneysforfreedom.com. On the top right, there's a red button. It says Attorneys on Retainer. If you click there, you will see the old version of our program that will be updated on September 5th. You can still sign up. Everything will be retroactive. Or just call the firm, and we're happy to talk to you about it. But I've done many comparison videos with some of our competitors out there, which are essentially clubs that have insurance companies. And the important thing to know here is that insurance companies cannot cover criminal acts. So if it's a bad shoot, right, they can't cover you. If you plead guilty, you lose your coverage. So, and like I pointed out, the stats are that you might take a deal at some point, and if you do, you just lost all your coverage, including your coverage if you're sued civilly, which could very well happen in a gun case. We cover that as well all the way through jury trial.
Let's see. What about states you aren't familiar with? Do you have difficulties representing clients in those?
Excellent question. There's a rule called pro hoc vice, fancy Latin term. It basically says we get admitted in another state for one case. And we do it all the time. At almost any time during the last 25 years, I've had several cases across the nation. The way it works is we hire a local attorney, and I vet the attorney. I don't want just anybody on my team. I find somebody who I can work with. We then hire them. They file a motion in court that says, hey, Mark wants to be admitted in our state for one case. The judge will say, is he in good standing in his state? Those kinds of things. We produce a certificate that says we're in good standing, and bam, now we're admitted for one case. Yes, the law is a little different, but it's really very easy for us to read the statute, see what the elements are. Virtually everything else is identical. What I need help with is, who's this judge? Tell me what this judge is about, some local things like that. But other than that, people get caught up in a sort of self-defense lawyer. There's a lot more to trying a jury trial than just knowing about self-defense law, right? There's all the motions that come before, working the prosecutor, dealing with discovery, picking the jury, just endless amounts of things that go along with a jury trial that have nothing to do with just knowing self-defense laws. It's an important part of the self-defense case, but still a pretty small part.
Following up on the carrying something other than a gun, is it a liability to carry pepper spray and a firearm at the same time? Will a prosecutor make a big deal about how I didn't de-escalate with the spray before I hypothetically had to stop an imminent threat with a firearm?
Yeah, it's a good question, and certainly I can imagine a prosecutor saying, hey, you had the pepper spray, why didn't you use it? So if you're going to carry that, now you have other options, because one of those things that's baked into the reasonableness analysis is what options were available to you. So if you brought pepper spray to the table, and pepper spray is something that could have resolved the situation, and you went straight for your firearm, probably going to have a problem, right? So you leave me with the argument that this was now an imminent threat of death or serious physical injury, and you had to go directly to the firearm. You didn't have time for the pepper spray. And of course, The other side will bring an expert that says, no, you had an option to use pepper spray. So I'm not discouraging people from using it, because there are times, like, imagine, and just think, just to sort of get a far out example, imagine you're carrying a firearm and you get in a fist fight. You don't get to pull out your firearm 9 times out of 10. And I say 9 times out of 10 because there are a few laws here and there that allow you to at least threaten to pull out your firearm against ordinary physical force. But for the most part, you got to get in a fist fight with a gun on your side. That's not a good situation for anyone. That's a great situation to have pepper spray or a stun gun or something like that, or a club or whatever. Again, best to avoid the situation if you can.
Okay. Does the local sheriff have overall veto power over gun collection, any gun collection activity by any higher authority?
No, the sheriff doesn't have that much power. I mean, of course, it depends a little bit in some of the different areas. Some places the sheriff is the only law enforcement in the area. They're law enforcement, and law enforcement has lots of discretion. But law enforcement doesn't have the power to bring a case, to charge a case. They do some misdemeanors in certain places, but they have limited powers. And, this is why it's good to have separation of powers. If you're going to have this government thing, it's good to break it down into different sections and have checks and balances. I'm a big fan of what some of the framers did in regards to trying to, and of course it didn't work very well, but the idea of trying to separate powers among the different branches is a good thing overall. But in many areas, the sheriff is only one of the law enforcement officials, and they just don't have a lot of power. Even if they say we don't recommend charges, a prosecutor could still bring charges. They might say we do recommend charges, and a prosecutor can still decline.
All right, let's see. I have likely a unique question. I fled Canada in November 2021 with my family. We're living here in Florida under a non-immigrant visa. We bought some land and recently had a couple run-ins with poisonous snakes, so I went to a gun store and tried to buy a shotgun to deal with it. Florida law enforcement called the store back, saying that USCIS blocked the purchase and that I needed to talk to USCIS about the issue. I've tried to get information but failed several times to talk to an agent. My immigration lawyer looked into it and was not able to get clarity either. There are supposedly several situations where a non-immigrant visa holder can purchase a firearm, such as tourist hunter. Do you have any insight into this issue or a resource I can look to for answers? Well, that does sound like an obscure question.
Yeah, it is a bit of an obscure question, but it has come up before in my practice, and there are some very tricky rules about people who are not United States citizens on different kinds of visas and what firearms they can have and not have, and it's not something I know off the top of my head. It can be very tricky. I'm sure that's the issue. I also worry a little bit about shooting that rattlesnake with the shotgun. I don't know where you are in Florida, but that may not be sufficient threat for you to pull out a shotgun and start firing away. You may be in a rural area and it's okay. I think I'd want to talk to the local police before I did that.
Okay. Are the insurance/organization memberships, for example, USCCA, helpful or worthwhile?
You're in luck. I did a very detailed video on the USCCA. You could probably Google Marc Victor, USCCA insurance. I also am going to be coming out with a video very soon comparing all of the different major programs with the Attorneys on Retainer program. I find a lot of problems with the USCCA. They're associated with an insurance company. There was a case, the Kayla Giles case. I don't know. Some people may be familiar with it. A USCCA member got in a self-defense shooting. USCCA originally paid $50,000 and then changed their mind and said, no, we don't think it's a good shoot. I personally had a conversation with the lawyer that USCCA hired, and I said, why did they stop paying you? He said, I don't know. I thought it was a great self-defense shoot. She ultimately got a different lawyer, went to trial, lost, sued USCCA, and the judge said, unsurprisingly, USCCA does not cover illegal acts. This was an illegal act. You were found guilty, so no coverage for you. This is the problem with all of the insurance companies. They can't cover the bad shoot, and the chances are good if you got charged, it's at least arguably a bad shoot.
Do you think the charges against Trump in Georgia are not evidence of legal corruption?
Do I think the charges are not evidence of
Because
legal
you were saying that actually most people in the system are not corrupt, and so he's trying to give you a counterexample.
of this being corruption?
Yeah.
Yeah, I'm not familiar enough with that situation to really comment on it. I get out of there. I don't think Trump is being treated unfairly. I think that Trump has very likely committed some very serious crimes. I know there were special prosecutors involved here. There were grand juries who, these are citizens who heard the evidence. Some of them very well were Trump supporters. They decided to return the indictment against Donald Trump. I think we need to be fair and even-handed about Trump. He's not all good. He's not all bad. Let's treat him like everybody else. And he should get a fair trial, and let's see what happens.
All right. I think we're getting down toward the end. Where can we research proper ways to handle threatening situations? You explained well how to decide when to produce a gun. Is there a resource that explains techniques for defense that are effective and have low risk of legal problems? For example, you mentioned saying, "I have a gun, leave me alone." Would that be, I think that means, would that be proper in most states?
Yeah, well, there are two varieties of advice here. One variety I like to call tactical, right? This is somebody who knows how to use firearms and is clear about what distances are appropriate and this and that. That's not something a lawyer should be answering. That's a tactical person. Then there are legal questions, right? How does the law work? And we usually use hypotheticals, right? Imagining this kind of a situation or that kind of a situation. But one thing I can recommend, and something that we're offering with our Attorneys on Retainer program, we're going to do a conference every year where I'm going to bring all my lawyers in. We're going to get on like this, and people can ask us different hypothetical legal questions that we will answer for them, whatever they want, till their heart's content. We're also going to bring in some tactical people to answer those kinds of questions, because as you can imagine, there's an infinite number of circumstances and situations. I've been answering these kinds of questions for 3 decades. But I will say this, just to leave it with you, most of my answers are going to be somewhere along the lines of, it depends what a randomly selected group of jurors from the local community finds reasonable. And that sounds pretty squishy intentionally, right? Don't rely on the jury to come back with the right answer. And it's often not clear. There are many times where it does happen where I say to the prosecutor, well, let's imagine this scenario. Do you think that would be reasonable? And we both say, I don't know. Maybe we should let the jury find out, which of course is no sweat off the prosecutor. If the defendant does 20 years, he goes home and has lunch. It's the defendant that takes the big risk in terms of trying to find out whether it's reasonable or not. And as I said in my presentation, most people will not want to roll the dice.
Okay, and then finally, in the case from last June about guns, apparently there is some discussion in there about what the laws were in 1776. But the question in the question tab is, "Shall not be infringed" makes no mention of existing law in 1776. Are you familiar with this aspect of the reasoning?
Yes, we're talking about the Bruin case, and we're talking about the aspect of the Second Amendment that says shall not be infringed. That does not mean that there can be no restrictions on the right to keep and bear arms. All it means is the right to keep and bear arms, whatever that encompasses, whatever that right is, that right shall not be infringed. You still got to decide what the right is. And I talk to people all the time who are gun guys who say the Second Amendment is absolute. And what I ask them to think about is, what about the person who is convicted of first-degree murder and sentenced to life in prison who says, I would like to bring my AR-15 to prison with me so I can shoot the guards when I feel like it? Would you tell that person they can't bring a firearm to prison? If the answer is yes, then you think there are some limitations. We could say the same for the 4-year-old who wants to say, no, I want to keep and bear arms and I want to carry my AR-15. We tell both of those people, you don't get to keep and bear arms for good reasons. I think we can say the same for violent felons, for people who are mentally ill, and for people who have no idea how to safely handle their firearms. They present substantial risks to other people, and that violates the non-aggression principle. And for that reason, I take that position on the Second Amendment. I'm more faithful to the non-aggression principle than I am to the Second Amendment, because there are many. First of all, the Second Amendment could be repealed, right? Secondly, There are many other things in the Constitution that we do not like. For example, like eminent domain. It's in there. I don't like it. I'm more faithful to the non-aggression principle, or as I now say, the live and let live legal principle, than I am to anything else.
Fair enough. No arguing with that. I have in the Q&A, such as Alec Baldwin. I guess we know his situation.
Yes, I mean, his was an interesting one. I thought that was a very interesting case. In fact, I think I did a video on that one that people could probably find. This is a function of, was he acting in a grossly negligent manner? But I kind of think that if somebody hands you a firearm and their job is to make sure that the firearm is safe, and you're an actor on a set, they say, here you go, the weapon is safe. I think it's reasonable for you to assume that it's safe. And while you might be negligent by not checking it still, I don't think you're grossly negligent. Okay, this is getting into that area why I think we need to have people with some training on the jury, because there's a difference between negligent and grossly or criminally negligent. It's a different standard. And that's the difference between whether it's a civil matter or whether somebody goes to prison for many years.
Let's see, I think that is the end of the official questions in the Q&A tab. So attorneysforfreedom.com is the website?
Yes, attorneysforfreedom.com. That's where people can find out about my law firm. I really hope that people check out liveandletlive.org. If you're a real libertarian, you will find nothing on liveandletlive.org that you disagree with. But what you will find is a whole moral principle that, of course, is a suggestion and not an obligation. We defend your right to disagree with the moral principle and act however you like, so long as you don't aggress. I think you'll find this is a global peace movement. And I think, Tom, you and I probably talked about this before, maybe on your podcast once, about the Live and Let Live global peace movement. So there's probably a podcast out there about this as well.
We did talk about it, and I just put the link in the chat.
Excellent.
Make it easy for everybody. All right, well, listen, I appreciate. Now, you're all the way out in Arizona. You still have half the day ahead of you, but I got to get up early in the morning, so this is like the end of my day. But I really appreciate you making the time to do this. This is really, really valuable information for everybody. I'm going to make sure and gently badger people into watching the replay, those people who weren't able to be here in person. So
excellent.
Thank you, Mark, very much. Thank to all of you, ladies and gentlemen. Please open the emails when I send them about these things. Even if you think you're too busy, you never know. I may have such a juicy one that you're going to be upset if you didn't open it. So keep an eye on those. Thanks again to Mark and all of you, and I hope you all have a great night. Thank you.